Hi, I am Zia Allen, and I am a funeral events coordinator here at Coastal Funeral Center. We have invited a few of our community partners to talk to us about trusts. This series will actually go into answering some of the questions regarding financial planning, trusts, and wills. And our topic is, what is a trust? We have here today Pete Pettler, an estate planning and probate attorney from Pettler, Miller, and Andover LLP in Torrance. Thank you so much for joining us today, Pete.
You're welcome.
For a lot of the questions that we have, I think the most common is, what is a trust?
Well, a trust is usually a written document, but the concept of a trust is that one person is managing someone else's assets. And that's the distinctive part about a trust. A lot of trusts, for estate planning purposes, have the same people who own the assets being the managing people for the assets, being the trustees. But we'll talk in a minute about how the flexibility of a trust allows that to change from time to time as things change.
Wow. I'm sure a lot of people didn't know that as well. I for sure didn't. But who are the parties of a trust?
Best to look at it from a standpoint of three kind of vantage points of people who are involved in a trust. And the first ones are called the settlors. They're also called the trustors, but I don't like that term because that's too easily confused with trustee, and people get confused with it. The settlors are the people that set up the trust, and although I'm sure that's not the Latin derivation of the word, it's easy to remember that the settlors are the ones that establish the trust. And that never changes. Whoever sets up the trust sets up the trust, and no one else is going to set up that trust or change that trust. And then the second component are the trustees. Those are the people that run the trust. And so they have to do what's necessary to manage the assets of the persons that have been placed into this trust in accordance with the trust document. So, for example, if the trust says, when I die, I want to leave a particular piece of property to so-and-so, they have to think long and hard before selling that piece of property, although that may be necessary depending on what's going on. And they also have, or they're what are called a fiduciary, and so they have responsibilities to treat the third category, who are the beneficiaries. Those are the people for whose benefit the trust is set up, in a proper business-like manner and looking out for their interests as well. And then the third component, as I just said, are the beneficiaries. Those are the people for whom the trust is being administered. Both the trustee and the beneficiaries, unlike the settlor, do change from time to time. So if a trustee can't act anymore, then someone else is usually named in the trust to say, here's the person that's going to take over and run the trust, basically. And then the beneficiaries of the trust change from time to time, too. Typically, a trust that's set up, let's say, by a married couple, the husband and wife are all three of those things. So they're the people that set it up, they're the settlors, they're the people who are running it, those are the trustees, and they're running it for their own benefit, so they're the beneficiaries. But as time goes by, it may be that one or both of them die, one or both of them lose capacity, or they just decide they're old and they don't want to do this anymore. And so then the trustee would change. Someone else would come in and take over. But again, they're bound to have to carry out the terms of the trust, and they've got this fiduciary duty to the beneficiaries. It's not absolutely essential with a typical trust, estate planning trust, but generally the beneficiaries are the people that set it up. Sometimes their kids or relatives may be present beneficiaries, but not real often. And then the beneficiaries also would change, though. So when the people that set it up no longer are here because they passed away, then there'd be some provisions of the trust that say, okay, now who does the trustee administer the trust for the benefit of?
Oh, how easy is it to change beneficiaries?
There are basically two types of trusts. There are revocable trusts and there are irrevocable trusts. An irrevocable trust can be revoked by the people that set up the trust as long as those people have capacity. And so that they could just say one day, we don't like this trust anymore, and it's gone. Or they could say, we want to change the beneficiaries. You know, we originally left everything for the benefit of our three kids, and we don't like one of them anymore. Or they've got a drug problem, or whatever the case may be, and they then could change that trust to reflect what their feelings are at any given time. One of them dies, then it depends on the kind of trust it is. Some trusts remain revocable until both people that have set up have died. Again, if you're talking about a husband and wife, I didn't mention it, but you also can have a trust with a single settlor. One person sets it up, one person is the trustee, one person is the beneficiary. But whenever the beneficiary, whoever that may be, has died, then the beneficiary is going to change and the trustee is going to administer for the benefit of that particular beneficiary. That settlor that set that trust up could change that from time to time. Once the settlor has died, then in a husband-wife trust, very often the survivor can change it. Sometimes the trust divides into two trusts, a revocable trust and an irrevocable trust, and then only the person that survived can only change his or her portion of the trust. And then when the second person dies, or if you have a single settlor trust, when the first person that set it up died, then the whole trust becomes irrevocable, which means nobody can change it, which is not 100% true, because an interested party can always petition the court to reform or amend the trust, and there are certain statutes about the grounds and the situations in which the court can do that.
Wow, that was a lot of information.
Maybe too much.
Could you tell us a little bit more about things that you've seen even as an estate planning and probate lawyer, from cases where maybe you would offer some caution for people who might be interested in creating a trust, or maybe are a little bit more hesitant, maybe some words that encourage them to consider having to create one?
Right. Well, first of all, everybody doesn't need a trust for estate planning purposes. In California, we have a small estate set-aside law that says if everything would pass to people that doesn't have beneficiary designations when a person dies, if it's less than, I think it's $186,000 this year, then it can be passed based on an affidavit. So you don't need to avoid having to go to court to get those assets passed. So that's one thing where you may not need a trust. Sometimes, fairly rarely, you can set up an estate plan, depending on what the assets are, where they're named beneficiaries to assets. So you can have, for example, a stock account, and you can name what's called a transfer on death beneficiary, and then when you die, the asset will automatically go to that person. There's no probate proceedings or court proceedings. Although it almost never happens anymore. When trust first became popular, one of the things that people were concerned about, and maybe lawyers were more concerned about than the people that they were doing the documents for, was the basic concept of probate jurisdiction of the court is to watch out for people who can't watch out for themselves, either because they're a minor under 18, they lack capacity, or they're dead. And so when you set up an estate plan that uses a trust, what you're doing is you're making an end run around that system, because what you want to do is avoid having the court involved, which is expensive and takes a long time. But sometimes that's a better approach, just because of the particular facts of the case. Maybe there are no close relatives at all, and the people who are the beneficiaries when the settlors of the trust die are 3 or 4 years old or something like that. You might consider maybe a probate would be better in that instance, because there'd be court supervision and there'd be bonds and there'd be things to protect those kids rather than them have to fend for themselves. But even then, what the court does is they appoint someone to look after their interests. So it's always dealt with one way or another. But the point is that the kids to start with are unable to assert themselves and make sure that things are being done properly. Another possible situation is where a person has no close family members at all. And of course, a trust is becoming more and more important to deal with the situation where the person that set it up, the settlor, becomes incompetent, or the terminology really is lack capacity now, because it serves really two functions as far as avoiding the court. One is it avoids having to have a conservatorship, which is a court-supervised proceeding while you're alive to manage your assets. And then it does away with having to have a probate when you die. So if the person that's setting this up has no one that's going to look after them when they're unable to supervise what's going on themselves, then it's always a consideration that maybe it would be better to have a probate, or maybe it would even be better to have a conservatorship than not. That's kind of doesn't happen very often. Why? Because there's some other ways of dealing with those problems.
When would someone actually need revocable and irrevocable trusts?
Well, usually revocable trusts are the most common sort of trust which we draft for people, because people are usually looking for a will substitute, and a revocable trust works nicely like that because just like a will, which doesn't go into effect until you die, a revocable trust can be changed as time goes by. And so people don't like the idea of setting up something that they can't change to reflect whatever's going on at a particular point in time when they're doing it for estate planning purposes. Irrevocable trusts tend to be used for tax savings, and generally you're talking about pretty high net worth people who would benefit from the use of an irrevocable trust. Sometimes you'd use a combination of revocable and irrevocable trusts. As I said a few minutes ago, in a typical estate plan with a husband and wife, it may be that part of the trust becomes irrevocable. It starts out revocable, becomes irrevocable when one of the two people dies.
And for those who are interested in opening a trust or starting a trust, what should the first steps be?
My approach for a long, long time has been to minimize the number of things that I ask them in the first meeting. But they need to have done some thinking about what their total net worth is. It's usually a big advantage to be able to know from a lawyer standpoint how much of that net worth is in retirement accounts and IRA accounts and how much is in other assets, because those are handled differently. And they might give some thought to who they want to name as trustees and who they want to name as beneficiaries. In an ideal world, I'd like them to list all that for me. I'd like to have recent documents for statements for each asset they own. I'd like to have deeds. I'd like to have stock certificates. I'd like to have the paper ownership of anything that they own. But I find that it's much more practical and works out much better to meet with them, see what they want to do, and then tell them, here's what I need. And then with computers and word processing, it becomes really easy in a document to say, just in boldface, that says, you need to tell me who your choice for trustee is, or you need to give me the bank account number of this bank account that you told me about. So that's how we usually do it. And I think that works out better than giving them a questionnaire or an insurmountable list of assets that they're going to use to decide never to come in the first place.
Thank you so much, Pete, again, for coming in to talk to us about trust. I know there's a lot of people who really benefited from your wealth of knowledge on the topic. So again, thank you so much for coming.
You're welcome.
And again, thank you all for joining us in this trust series. We greatly appreciate being able to hold this together for all of you to learn more about trust. Again, for any additional information, you can find us at coastalfuneralcenter.com, or you can give us a call at 310-326-6343. Thank you.